In Florida, a broken air conditioner is not just an inconvenience, it can be a serious health and safety issue, and Florida law recognizes that. Under Florida's landlord-tenant law, landlords are required to maintain rental properties in a safe and habitable condition. In Florida's climate, working air conditioning is generally considered part of that obligation. If your landlord refuses to fix a broken AC, they may be violating the law. Here is what to do. First, put your repair request in writing immediately. A text or email is fine. This creates a record and starts the clock. Once your landlord receives written notice, they generally have 7 days to begin repairs for conditions that affect health and safety. Second, document everything. Take photos and video of the broken unit. Record indoor temperatures if possible. Save every message with your landlord about the issue. Third, if your landlord still refuses to act, you may have legal options, including the right to seek repairs, withhold rent through the proper legal process, or terminate your lease. But, and this is critical, you cannot simply stop paying rent without following the correct legal steps first. Doing it wrong can get you evicted. If your landlord refuses to fix the AC in Florida, call Corda & Associates at 561228620 or visit cordapa.com for a free case review. We represent tenants throughout Florida, never landlords.